morning. My name is Greg Overstreet. My address is 1110 Capitol Way South, Suite 225, Olympia, Washington. I'm an attorney with Allied Law Group. We represent Joe D'Amico, and we specialize in, we focus our practice on enforcing the Public Records Act. Mr. D'Amico has just made a public records request, as he described, for emails relating to county business. I want to be very clear, relating to county business that are on private or campaign emails, that are on non-county emails. You might be thinking, well, Public Records Act, that only applies to things that are in county file cabinets or that have an email address at Jefferson county.wa.gov or something similar to that. That's actually not true. I'd like to read from the Attorney General's model rules, which I was very fortunate enough to be able to write when I was at the Attorney General's office. And it's a short quote. It says, sometimes agency employees work on agency business from home computers. These home computer records, including email, were used by the agency and relate to the conduct of government, so they are public records. Because the home computer documents relating to agency business are public records, they're subject to disclosure unless exempt. I'd also like to note Thursday's decision of the Washington State Supreme Court. This was a case in which our firm represented the public records requester, and we succeeded in the Supreme Court. The Supreme Court made some new law. Actually, they just clarified what the old law had been. And the Supreme Court upheld the model rule I just mentioned. And this was a case about non-city emails that were requested from the city of Shoreline. The Supreme Court said, and this is extremely important, if government employees could circumvent the Public Records Act by using their home computers for government business, the Public Records Act would be drastically undermined. So please don't believe that just because the emails that have been requested aren't on county email accounts, that they are not public records and that they are not subject to disclosure. Another point that should be made is that under RCW 42.56.100, any requested public record cannot be destroyed unless the request is, quote, resolved. Mr. D'Amico will let you know when the request is resolved. So all the requested emails cannot be destroyed, even if they could otherwise be destroyed under a retention schedule. It is Class C felony to unlawfully destroy public records, and that's RCW 40.16.101. So this is an extremely serious matter. So please, you don't have insurance for this Public Records Act case. You did last time, you don't now. Please do not assume that you don't need to turn over these records, or do not assume that you can destroy them, because you cannot. Thank you very much.
Thank you. Anybody else?